The subcommittee has maintained its recommendations that the prohibitions on the use of outcome-related fee structures in arbitration should now be lifted, and lifted as quickly as possible. The responses show that this is very much what stakeholders and users of arbitration in Hong Kong want and in fact need. And critically, from the Hong Kong public perspective, this brings Hong Kong into line with other major arbitration seats. It allows Hong Kong to maintain its status as a leading arbitration seat. It allows us to be competitive, which benefits everybody in Hong Kong, and including the legal profession, but also the users of arbitration, because we are seeing that clients are demanding that we be permitted to allow these types of fees, so that they can keep choosing to seat their arbitrations in Hong Kong. And in fact, given the rise in arbitrations involving mainland Chinese parties, including claims arising out of the Belt and Road Initiative, of which there are an increasing number in Hong Kong, it's important that we can charge legal fees on the same or a similar basis to our counterparts in mainland China, where these types of fees have been permitted and in fact have been working very well for some time now. There are three types of outcome-related fee structures that we have recommended be permitted in Hong Kong. The first are what we call conditional fee agreements, or CFAs, where lawyers charge benchmark fees or a discount to benchmark fees and an uplift on those fees if the case is successful. The second type are what we call damages-based agreements, or DBAs, and this is where the lawyer charges no fees through the lifetime of the arbitration, but takes a percentage of the financial benefit that the client obtains in that arbitration. And the last type is what we call a hybrid damages-based agreement. And these are agreements that are suited to long-running, complex, sophisticated commercial arbitrations, where it would be difficult for a lawyer not to charge any fees at all through the lifetime of the dispute, that they are permitted to charge a discounted fee and then also to take a percentage share of the outcome once the arbitration has concluded. So in light of the overwhelming support from the responses we received, the final report recommends that all three types of outcome-related fee agreements be permitted for arbitration in Hong Kong, and that the existing legal prohibitions be lifted. We recommend that any agreement dealing with these types of outcome-related fee structures should be in writing, that they should state clearly when and in what circumstances the lawyer's fees and expenses should be payable. They should say clearly what is the definition of success and financial benefit, which we have recommended should be as broad as possible to meet demand and provide flexibility to clients. There will be a minimum cooling off period of 7 days, which actually is longer than many other jurisdictions which have 5 days, but we felt that that was an important safeguard for clients entering into these types of arrangements in case the client changes her mind. And the lawyer also has an obligation to inform the client of the need and the right, in fact, to take independent legal advice.